All right, Kelly, thank you so much. Good morning. It's still morning here, so good morning. I'm happy to be here with all of you. My name is Ali Talai. I'm a trust and estate planning attorney here in Woodland Hills, California, and we get to do a lot of trust administration, advanced estate tax planning, your regular revocable living trust, probate, and trust administration. That's sort of the work that we do. Today, in the first session, while I'm here with you, I'm going to sort of talk to you about marital trust. And as I was working through putting the presentation together, I just couldn't really talk about marital trust without talking about, the credit shelter trust, the B trust. So as you'll see through the presentation, my goal is to first go through these acts. I mean, they're definitely old news, but it was these acts that I'll go through with you that made it different on how we really now do state planning, or some of the factors that become more important in putting a trust together. So we'll go through that, and then I'll talk to you about the different options, and we'll sort of compare and contrast that, the B trust, the marital trust, and all the other stuff that that we'll talk about. So it really all started in 2010, this Tax Relief Unemployment Insurance Reauthorization and Jobs Creation Act of 2010, which became effective December 17, 2010. This act created this whole concept of portability. Before December 17, 2010, there was no portability. So when you were doing an estate plan, and as if you have seen older estate plan, you'll get to see this sort of requirement, this shall language in the trust that says you have to fund the credit shelter trust, the B trust, and then they, whatever was sort of left would go into the marital trust. There was no concept of portability, and the only way the surviving spouse, could use the unused exemption amount was to, fund the B trust, and that was it. If she or he didn't do that, the unused exemption amount was lost. What portability did, it allowed it to, it created the idea, and it allowed the surviving spouse to have the ability to port whatever unused exemption amount was there. So then that really was the first sort of step in some of the planning that we'll talk about. And then came the ATRA rules, and what ATRA did, the American Taxpayer Relief Act of 2012, which became effective January 1st of 2013, as it relates to estate planning, it permanently extended the $5 million exemption for gift and estate taxes, also for GST. It's indexed for inflation. Currently in 2024, the exemption is $13,610,000. That's per individual that is a U.S. citizen or has a green card. Portability became permanent. 2010 was not a permanent effect of portability. It was really the introduction. 2012, ATRA made it permanent. And realistically, when portability became effective, it really increased the total exemption that spouses have. They doubled up the exemption that they could have. And then what else did it do? The tax rate. So before 2012, the last couple of years before that, 2010, 2011, the tax rate was 45%, and then ATRA set the tax rate at 40%. So whatever is above the exemption would be taxed at 40%. And it unified it. So it's the same thing for estate taxes, gift taxes, and GST taxes. For example, in 2010, the estate tax exemption was $5 million, where your lifetime gift tax exemption was only $1 million. So now everything is the same, and annual exclusion amount wasn't changed. It stayed at what it was. This year is 2024 is $18,000. And then came the Tax Cuts and Jobs Act of 2017. And it, for estate tax purposes, it increased the exemption. It doubled the exemption to 10 million. They didn't get enough votes, so it's temporary. It's effective from 2018 to 2025. In January 1st of 2026, the exemption is set to go back to what it used to be, the 5 million. Most likely is still an index for inflation. So I'm thinking that in 2026, the exemption would probably be around 7 to 7.5 million. As I indicated before, currently is at $13,610,000. All right. So when we started having this whole idea of portability, then a lot of times the question came that, you know, as we started, a lot of planners have started sort of questioning the use of AB trust. And again, before portability, AB trust was really important because the only way you were able to save the exemption amount that the C spouse had was to fund the B trust. The B trust is the credit shelter trust. It's for the spouse that is below the ground. This is how I remembered this AB trust, because I don't know why. And I asked ChatGPT to see if it could tell me, why do we have credit shelter trust, bypass trust, family trust, non-marital trust, the B trust? Why do we have 5 different names for the same thing? And based on the answer I got from ChatGPT, it seems like it doesn't know either. But here in the presentation, I'm mainly going to refer to it as the B trust or the credit shelter trust. And that's really the portion that would be intended to hold the deceased spouse's share. Exemption could be applied to it. So the question, again, so before you had to do this to use the exemption. And then we got portability. So then the question was, why do we need to fund the B trust? Why don't we just have everything go to the A trust? The problem with the credit shelter trust, if it's drafted just sort of your standard version of it, you don't get a step up in basis at the time the second spouse passes away. So that was one of the problems with having a credit shelter trust funded. If you have a taxable estate, or if you have a estate that is, you know, more likely susceptible to paying estate taxes, then yes, we want to fund the B trust, because the assets that are inside of the B trust, credit shelter trust, are outside of the surviving spouse's share. So at the time the surviving spouse passes away, there'll be that asset is not included in her estate, so there will be no estate taxes on the asset that are in the credit shelter trust. However, if we don't have a taxable estate, it sort of backfires, because now you're not getting any step up in basis in the assets that were in this credit shelter trust. There are no estate taxes to pay anyways, so we're not saving any estate taxes, but then at the same time, we're not getting any step up in basis. So one of the problem with a sort of a standard credit shelter trust, if you don't have a taxable estate, is that you're not going to get any step up in basis. The other issue with credit shelter trust, or a lot of irrevocable trust, is that you have, if there's income trapped within the trust, you're going to end up paying a much higher income tax on the income that is trapped in. If the assets, or if the income is reported on the individual's tax return, let's say it's the surviving spouse and she's single, for 2024, the highest tax bracket, if you're filing under personal or under trust, it's 37%. So no different in the actual tax bracket. The difference is at what income we hit 37%. So if you are a single person, you hit 37% after you have more than $609,351 of income. If it's in the trust for 2024 is $15,200. So now at a much lower income, you are paying the highest tax bracket. So that's the issue with this irrevocable trust, the credit shelter trust. And so these are some of the factors that I would get to hear from advisors or CPAs or other attorneys sort of saying, hey, why are we using these credit shelter trusts? Why don't we just, give it all to the surviving spouse? And I'll tell you why that probably won't be the best decision. Obviously, as being a trust attorney, we have a bias for making sure we want to use trust, but we have good reasons. I really think so. And there are times that it might be okay that you have a trust that at the time the first spouse passes away, you distribute everything to the surviving spouse. It goes to the surviving trust. Maybe it's a long marriage. There's no issue. Spouses are older. There's no chance of remarriage. And yeah, so that might be the option. But the other sort of concerns are issues like blended families. If you have a blended family, if you want to make sure that the asset stays within your family bloodline, having everything go to the surviving spouse, you could see the problem, right? Because the surviving spouse can do whatever he or she wants to do. If at some point she gets remarried and because of whatever reason decides to make a distribution to someone outside the family, he or she can. So having a trust in place, having the deceased spouse's share placed into the credit shelter trust or the marital trust provides this option, the ability to save the assets and make sure it stays within the family bloodline. It also makes sure that if it's a blended family and they have kids from different marriages, they have separate property that they acquired before marriage, it allows the surviving spouse to be taken care of, to keep her lifestyle or his lifestyle while they were married, same sort of lifestyle. But then at the same time, it allows us to have these different distributions. And so we could make sure each spouse could indicate their share of the asset goes to their own kids and nobody could really mess with it. So those are two of the main reasons. The other one is asset protection. Assets that are placed into the credit shelter trust, marital trust, they receive asset protection. The assets that are being placed in these trusts, they are not the assets of the surviving spouse. They're the assets of the deceased spouse. So this marital trust, credit shelter trust, these are not self-settled trusts. And in many states, beside this DAP jurisdiction, 1920 states that have DAP jurisdiction, DAP laws, domestic asset protection trust laws, if you create a self-settled trust, you don't have any asset protection. I don't care if it's an irrevocable or whatever else you want to call it. These trusts, the asset protection, because the assets that are going into the marital trust or the family trust, credit shelter trust, are not the assets of the spouse, they get a very good asset protection around them. So now if something happened, the surviving spouse gets into some sort of trouble, car accident or some sort of lawsuit, the creditor may be able to take the assets that are in the survivor's trust, but it would be very difficult to have access to the assets that are in the credit shelter trust or the QTIP trust. The other issue is this whole portability. It's great. We use it a lot. We filed 709 tax returns and different things that needs to be done, but there are some problems with it. And those are stuff that you definitely want to keep in mind. One is the SUI amount. This year, a spouse passes away this year, $13,610,000. That gets ported, but it doesn't get indexed for inflation. It's just $13,610,000. That's it. If you have funded $13,610,000 in the credit shelter trust, and at the time the surviving spouse passes away, let's say now this has $26 million worth of assets in there, that entire asset, that entire bypass trust is exempt from any estate taxes. So that's something to keep in mind. Simultaneous death becomes an issue. Remarriage, this is the one that could be pretty problematic. The SUI amount, the ability to port the unused exemption amount of the deceased spouse only applies to the last deceased spouse. So let me give you an example. Let me read this here. So the SUI from the first deceased spouse is lost if the surviving spouse remarries and outlives their next spouse. Let's say my example here, John and Mary, they're 58 years old. They have a $10 million estate. John dies and Mary decides that she's going to file the 706 to be able to port the unused exemption amount. This portability, the other thing, and I do have a bullet point, it doesn't happen automatically. There has to be a tax return file, a 706 tax return. So that's the other sort of thing that the surviving spouse has to do. And as you all know, a lot of times getting the surviving spouse to do what the trust says that you're supposed to do, or things that should be done, becomes difficult. But in my example here, so I got John and Mary, 58 years old. I got my notes here, $10 million estate. John passes away. We always kill the husband in our examples. I'm not sure why, but I stick to it. Mary files a 706. Let's say the trust allows her to fund everything to the survivor's trust. She does that. She has her $13,610,000 exemption. She got her, deceased husband's $13,610,000 times 2. That's $27,220,000 of exemption. If she feels good. They have $10 million worth of assets. She's good. She gets remarried. The new husband is wealthy. He's done, all the estate planning that he needs to do. He's used all his exemption amount. He does not have any exemption left, any gift tax exemption, GST exemption, nothing. And then 10 years into their marriage, the second husband passes away. In this case, as soon as the second husband passes away, that DeSuey amount that was filed to the 709 that was filed, the 706 that was filed to transfer the unused exemption amount of John, the first husband, that goes away. Because as you remember, I mentioned here, it's the last deceased spouse. So now at this point, what Mary can do, she can file another 706, but as I mentioned in my example here, the second spouse doesn't have any exemption left. He's used everything. So there's obviously no point of filing a 706. So now she's stuck with her then exemption amount. And let's say for my example that there is no change. The exemption is still $13,610,000 10 years down the road or 20 years down the road. In a state, so if you have a $10 million estate, if it doubles every 14 years, that's pretty conservative. That's about a 5% increase on a yearly basis. That means she's 58 plus 14, that's 72. I know math is not our strong suit here, but let's go with this. So 58 plus 14 is 72. That means that 10 million at the time Mary becomes 72, it's $20 million. Let's say she lives till 86. It works good for my example here. 72 plus 14 is 86. So by the time she's 86, this becomes a $40 million estate. And you could see, even if the exemption stays the same, you still have a taxable estate. And now you have the issue. It would probably have been a much better decision if she had funded the credit shelter trust and used the exemption that way. When you have trust, particularly credit shelter trust, V-trust, you could have the ability to have a spray power within the trust. And what that means is that it's a limited power of appointment, and it allows the surviving spouse to shift income. It's income tax planning. So now if the surviving spouse is making 600, 700,000, she's at the highest tax bracket, and let's say they have children or grandchildren that are at a lower tax bracket, that ability to be able to shift income becomes huge. And then state estate taxes, inheritance taxes. Luckily here in California, I think they forgot about this. We don't have any estate taxes. But if, let's say, the couple moves, or the surviving spouse moves to a different state, that may have it. Again, so these are some of the issues that we think of for reasons that why we would want to have this trust. All right, so the person that I'm supposedly arguing with here, the advisor says, okay, great, you make great, points, but why the B trust? Why don't we just have the marital trust? Everything to the marital trust. The marital trust gets a step up in basis, great. And it gives that asset protection and all the stuff that you were talking about, the family bloodline, all that great stuff. And yes, that's true. The marital trust does get a step up in basis. However, it also gets a step down in basis. I know in a lot of times when we talk about the step up in basis, we just sort of refer to it as step up in basis at all time. But the reality of it, section 1014 indicates, an adjustment to fair market value. And that could mean possibly a step down in basis. You may remember 2008, 9, and 10, there was definitely some step down in basis back then. So that's one of the issues which I'll address with you in a bit. But going, this is a marital trust in a nutshell. So I got to make sure I spend some time on marital trust planning and sort of some of the features of that. There are three main marital trusts. Realistically, QTIP is the one that everybody knows that gets used the most. Estate trust is a type of a marital trust. It's a trust that requires the trust to pay everything to the surviving spouse's estate. I've never seen one being used. The GPOA marital trust, that I have seen, and that's a general power of appointment marital trust. It grants the spouse the power to appoint to his or her estate without any other consenting party. That part is really important. The consenting party becomes really important. The QTIP trust, again, that's the one that gets used more often. And it provides a little bit more flexibility, a little bit more control. It's a little bit more restrictive. Again, so maybe in a second marriage, or if we're concerned about somebody being disinherited, a QTIP trust could be a better option than the GPOA marital trust. The GPOA, general power of appointment, gives the surviving spouse a pretty large, ability to be able to do whatever he or she wants to do. She can appoint the asset of the trust to herself, to her creditors, to her estate, or to her to the state, the creditors of her estate. And so that probably wouldn't give us as much control if we want to, but these are the options. Let's talk about requirements for making a trust a QTIP trust. And keep in mind, when you're looking at older trust, it doesn't really matter if on top of it, it refers to it as a QTIP trust or not, or some other name. I have seen credit shelter trust that would actually qualify to be a QTIP trust. So again, keep that in mind. One other thing with QTIP, I had a client that came, and it was the son and the mom. And the son said, oh yeah, we've done some trust administration. We funded the QTIP trust. I was like, that's great. Very nice. When did you filed the 706? And he was like, what is that? What do you mean? And the reality of it is, just because on top of the trust, it says QTIP, it does not mean it's a QTIP trust. All it means that it could be it's a QTIPable trust. In order for a trust to be a QTIP trust, you have to make an election on 706 tax return. So again, that's another sort of a part of this QTIP trust that would have to happen in order for it to be a QTIP trust. On a GPOA marital trust, there's no there's no estate tax returns needed. There's no elections that needs to be done. So marital trust, QTIP trust, usually all income has to be payable to the spouse. You could make a QTIP trust a grantor's trust under the 678 rule. And if the surviving spouse is entitled to all the income, that makes the trust a QTIP. She does not, or he does not have to withdraw all the income out. So that's sort of important right there. The power of appointment is limited. There's no lifetime power of appointment unless the surviving spouse is appointing to herself or himself. You could have a testamentary limited power of appointment. It qualifies for the unlimited marital deduction. The election is irrevocable, and you list it on Schedule M of the 706 tax return. You get 9 months, and then you have another 6 months of an extension to file this estate tax return to make a trust a QTIPable, make a trust a QTIP trust, a trust that is a QTIPable trust. Okay. Reverse QTIP. You're gonna have me talk to you about GST in a little bit. So this really QTIP, reverse QTIP trust is really a way to be able to transfer the deceased spouse's GST tax to the transfer that is being done. Portability allows the surviving spouse to transfer the estate tax exemption to the surviving spouse, the gift and estate tax exemption. GST is not portable. You cannot port the unused amount of the surviving spouse of the deceased spouse to the surviving spouse. So the only way that you could preserve the GST tax exemption or exemption is funding a reverse QTIP trust. A reverse QTIP, the assets that are in a QTIP or a marital trust, they are included in the surviving spouse's estate. So at the time the first spouse dies, whatever assets goes into the QTIP is not taxable at the time the first spouse dies. It qualifies for the unlimited marital deduction. But all we're really doing, we're just sort of kicking this down the road and saying, well, IRS, you get to get a second look at the time the second spouse passes away. So in a reverse QTIP, the assets that are in there are still included in the surviving spouse's estate. The only thing is they're exempt for GST taxes if there is a distribution to a skip person, which we'll talk about. So that is your reverse QTIP sort of setup. I probably won't go through all the bullet points. You could take a look at it. But what I want to talk about is this Clayton QTIP election versus disclaimer. So I'm sure most of you have heard Clayton case and the disclaimer as you're drafting these trusts. Most of the softwares have these options, and you get to pick how you want to fund the marital trust. This QTIP, Clayton QTIP or disclaimer, it's just a mechanism to fund the marital trust, and whatever doesn't go into the marital trust will go into the credit shelter trust. Disclaimer funded B credit shelter trust allows the surviving spouse to choose how much to be allocated. If we're doing a disclaimer, there are certain requirements. In order for the surviving spouse to disclaim whatever portion that she or he wants to have transferred into the B trust, there's these requirements. Must be in writing. It has to be done within 9 months of death. With QTIP election, you have the 9 months plus the 6 months, so you get a little extra time. After you make the disclaimer, it's irrevocable. You cannot change it. The other problem usually with disclaimer is that the disclaimant must not have accepted any benefit from the asset. So the surviving spouse cannot disclaim a property where she's been using since the husband passed away, or a bank account or an asset that it's been giving her benefit if it's living there or using the actual asset, the income from it or whatever. That sort of disqualifies this whole disclaimer. So there's more restriction within this disclaimer amount, and obviously would have to comply with state laws as well. With the Clayton election, you don't have those restrictions. The fact that the surviving spouse used some of the benefited from it doesn't make it different. And you have the ability to sort of get the extra time. All right, so going through the marital trust options again, you have the QTIP trust, most common choice, requires a 706 in order for you to be able to have the trust be considered a QTIP trust. And the GPOA marital trust is less common, but may provide the benefit of sort of getting things in place easier, no need to file a 706, but the GPOA is there, the general power of appointment is there. That general power of appointment cannot be subject to a non-adverse party. As I'll talk to you, you could create a trust with a general power of appointment and have a non-adverse party sort of approval requirement and get to where we would want to get, which I'll talk to you in a little bit. But in a GPOA marital trust, it's absolute. The surviving spouse has to have 100% control. However, the problem with the QTIP trust is it gets a step up in basis, but it also gets a step down in basis, right? So that's not favorable. There is no ability to be able to do the spray power to shift income between any of the beneficiaries within a marital trust. Marital trust says all income to survivor, or the survivor has to have absolute control over the income. So that you can't do any income tax planning within a marital trust. That's the other problem.
The third problem is having to file the 706. If you haven't filed the 706, it's not a QTIP. So the other problem with a marital trust is a problem that is overlooked often, and it's this whole idea of, it does get a step up in basis, but it has a fractional interest QTIP has fractional interest in there. So then the question is, does the entire asset gets a step up in basis at the time the second spouse passed away, or they're valued separately? Most of you are probably familiar with discount valuations, discount for marketability, non-controlling interest, lack of marketability, I mentioned, minority interest, all those things. And those are great when you have a taxable estate, but when you don't have a taxable estate and you're trying to get the highest value for the asset for that value to be now the new basis of the property, having everything funded into a marital trust and a survivor's trust, there's an issue here. If you have funded the entire asset in a GPOA marital trust, so now the surviving spouse has a general power of appointment. Under Internal Revenue Code 2041, if a person holds a general power of appointment, they are considered to be the owner of the assets. And so if I have assets that are in a GPOA marital trust, 50% and 50% in the survivor's trust, at the time the surviving spouse passes away, they're aggregated. They're considered as I own the entire amount. So in my example here, $1.2 million, 900,000, that's 2.1 million. That's when it got funded. Let's say at the time the spouse passes away, the surviving spouse, it's doubled. So now it's 4.2 million collectively. That means I have 2.1 million in the surviving spouse's trust, 2.1 million in the marital GPOA trust. Again, because of the general power of appointment, they're considered to be the same. The step up in basis, it's the $4.2 million. If you have the asset in a marital trust, QTIP trust, you are not able to aggregate them together. They're valued separately. So now if you have 50% of an asset that you're going to value, you're going to have issue with marketability, non-controlling, all those discounts that you give. At this point, we don't want the discounts because we want the higher value. So one of the other problem that QTIPs have, you end up getting a lower step up in basis because of these fractional values that goes and fractional sort of calculation that are placed for these sort of QTIP trusts. All right, so you may say, okay, what's the solution? And before I get to the solution, I want to quickly talk to you about powers of appointment, general powers of appointment, and limited powers of appointment. General powers of appointment allows and gives the power holder the ability to distribute the assets or transfer the assets to himself, his state, to his creditors, and to the creditors of his state. It's not an and, it's an or. So I could create a general power of appointment that says, my surviving spouse has the power to appoint to her creditors. And if she holds that power under Internal Revenue Code 2041, she's deemed to be the owner of the assets. And so, as you might be sort of figuring what I'm trying to get to here, is that we could create a trust that would allow us to get a step up in basis at the time the surviving spouse passes away without it being a marital trust or without it being a QTIP trust. Before I get to the part about the trust, I forgot about this slide. So sometimes the question is, you get a client that comes in, they have a trust, and we're trying to figure out, again, maybe the trust was done before 2010, or maybe there wasn't a whole lot of thought put into it. And now we got asset into a credit shelter trust, and the surviving spouse is older, and we're trying to figure out how can we make sure those assets get a step up in basis. And so the first thing, hopefully it has a trust protector provision in there. Vanessa was talking about that. If it has that, a lot of times if the trust protector has the ability to provide a general power of appointment to the surviving spouse, then that could allow the asset in the credit shelter trust to get a step up in basis. We may have to do, court ordered amendments or reformation, those sort of things. And then the one other thing that I want to discuss about this whole getting a step up in basis, this QTIP trust, I talked about you have the 9 months and the 6 months to file. And if, that's your timeline, but the reality of it is you can actually file a late, really late, return to elect a trust to be a QTIP trust, as long as it's the first filed return. So let's say you get a client comes in, the trust is 20 years old, they funded this thing 20 years ago, there are assets in there that are much higher than what their bases are. And then again, it doesn't matter if the trust says bypass trust on top of it or credit shelter trust. You want to read it. If the trust gives 100% income to the surviving spouse, there's no powers of appointment, lifetime powers of appointment to anybody else, that trust could qualify for a QTIP trust. So then all you would do is file a 706, elect for that trust to be a QTIP trust, and now you got a new, at the time the surviving spouse passes away, gets a stepped up basis, better than not getting anything, even though, as I mentioned, the QTIP trust could have its own sort of problems, but it would at least get, a large portion of it would get a step up in basis. All right, so the other portion here, as far as the alternative method to adopt a credit shelter trust, bypass trust for basis, it's this thing called optimal basis increase trust. Ed Morrow talks about this. A lot of the stuff that I'm teaching you today, I've learned from him. He's very knowledgeable, a great attorney. And this whole idea of optimal basis increase trust, the idea is that we want to really sort of trick up this bypass trust and take away this no step up in basis in there. Because if I create a credit shelter trust and I give my surviving spouse this general power of appointment, we put some caps on it, some ordering rules, make sure that if it's an asset that's gone in value, it doesn't apply over it. With all those sort of language, we could create a trust, a credit shelter trust, that at the time the surviving spouse passes away, they'll get a step up in basis. If that's, that's what happened to the assets, they've gone up in value. But if the assets have gone below whatever the fair market value or whatever their basis is in the trust, if their value is below that, this general power of appointment would not apply to those assets. So it's a formula general power of appointment. It's not a current, it's not a lifetime general power of appointment. It's a testamentary general power of appointment, which means it only becomes effective at the time the spouse passes away. That is sufficient to get a step up in basis. With these GPOA marital trusts, I mentioned that the surviving spouse's general power of appointment cannot be restricted. However, when we're creating and drafting this sort of language within a credit shelter trust, it could be subject to a non-adverse party. So we could have a language in there. Again, like somebody may argue saying, well, you just went through this whole GPOA marital trust saying that the surviving spouse could, make a transfer to somebody that we don't want to. And now you're saying you put it into this credit shelter trust. The difference is that when we're in the credit shelter trust, I can have a consenting party in there. I could have the trust protector. I could have the attorney that drafted the trust. I could have, and it doesn't have to be one person. It could be multiple people. And the way this power of appointment works under 2041, there's no requirement that it has to be exercised. The fact that the surviving spouse has that power by itself is sufficient for the asset to be included in his or her estate. And again, like I was saying, we could have this whole setup, this asset structure set up in such a way that we'll get a step up in basis, but we don't get any step down in basis. And then what else? And I saw the note, I forgot what I was saying. Anyway, so that's kind of gives this a trust the ability to be a better trust. you don't have to file a 706. So at the time the first spouse passes away, if everything is, the deceased spouse's share is allocated to the credit shelter trust, there's no need to file a 706. We have this testamentary formula general power of appointment in there to take care of what we need to do as far as getting a step up in basis. We could have the trust protector to make sure my spouse doesn't just give the asset to anybody. In California, there's some credit issues that if you have a general power of appointment and now the spouse passes away, or the creditor can reach the asset that general power appointment is over. And again, we're making it a testamentary, and we could have language in there that says if the deceased spouse's estate is insolvent, there is no general power appointment. It sort of goes away. Again, so with that formula, we could sort of plan around all the negative things that could come up. The other way to get a step up in basis is using this Delaware tax trap. And this is a limited power of appointment. And I definitely don't have time to really explain this, but the idea is that if you see it, if you draft the trust, let's say there's a credit shelter trust, the surviving spouse has a limited power of appointment. If she appoints the assets of the trust, or some of them, it doesn't have to be all of them, into a new trust, and the children have a current general power of appointment, that's how you have this tax Delaware trap sort of put in place, so that would allow a step up in basis. I have some sample language here. QDOTs for non-citizen spouses. That's a way to be able to transfer asset to the surviving spouse. This is really a transfer from, in most cases, it's the citizen spouse and a non-citizen spouse. The citizen spouse passes away, and now we're transferring to a non-citizen spouse. That's when these QDOTs become important. One thing that I've learned recently, that you don't even have to have a QDOT in place. Technically, you could set up a QDOT after the person has passed away. But obviously that's not something you want to rely on. You want to make sure you have it in there. If you have a client that has a surviving spouse, there's a non-citizen spouse in there. There's some restriction as far as how the QDOT has to be set up. It requires the trustee to be a U.S. citizen trustee or a domestic corporation. If there is any distribution of principal, estate taxes will be applicable. If there's only income that has been distributed to the surviving spouse, there's no estate tax ramification. And then compliance with all the regulation, that's all good. I think that is the last slide I have here. Yeah. I do have a little bit of a sample language as far as the testamentary general power of appointment. I hope that's helpful. And I hope the information I shared with you was helpful. And I don't know if there's any question, Kelly, but I could definitely try and attempt to answer some questions if there are any time. If there is no time, then I'll be available via email.